Today we will talk about the offense of perjury and contempt and the procedure of trying those offenses under Bharatiya Nagrik Suraksha Sanhita. The term perjury is not used under Indian law, but it is used in English law. In India, the term uses false and fabricated evidence. Perjury is committed if false or fabricated evidence is produced before the court so that it can be used in a proceeding against the person. Now, the offense of false and fabricated evidence is covered under section 227 to 231 of the Bharatiya Nyaya Sanhita. The procedure of trying the offense of perjury or false or fabricated evidence is given under section 379 to 383 of the Bharatiya Nagrik Suraksha Sanhita. Now, the provision says that the court before whom the offense of perjury is committed has a right to make a complaint to the magistrate to try the offender. Now, the court can exercise this power either suo motu or on receiving an application of the opposite party against whom the evidence is given. Now, the court decides not to make a complaint. In that case, the superior court has also right to make a complaint of that offense. Now, if the court makes a complaint or decides not to make a complaint, in both cases, the aggrieved party can move to the superior court and appeal. On appeal, the appellant court can order the making of the complaint if the complaint is not made, or withdrawal of the complaint if the complaint is already made by the court. Now, the magistrate can try the offender and can follow the procedure which is given for the cases instituted on police report. If the offence is committed before the court of session or a magistrate, then they are also allowed to try the offender themselves following summary procedure. And they can punish the offender with fine up to ₹1,000 or imprisonment up to 3 months or both. Now the next offence is contempt of court. In contempt, there is a disobedience of the order of the court. The offences for the contempt is given under section 210, 214, 215 and 267 of the Bharatiya Nyaya Sanhita. If we talk about the trial of the contempt, it is covered under section 384 to 391 of the Bharatiya Nagrik Suraksha Sanhita. It lays down that if the contempt is made of the court, in that case the court is authorized to try the offender by taking cognizance of the offence. The court can sentence him with fine up to ₹1,000, and in case of defaulting making the payment of the fine, in that case imprisonment up to 1 month can also be given. It means for contempt the court can only impose fine and there is no imprisonment for it. Only in case of default of fine that imprisonment can be given. Now, here for the contempt proceeding, the court means civil court, criminal court as well as revenue court. And the state government, if wants, can cover registrar or sub-registrar appointed under the Registration Act 1908 can also cover them under the term court for the purpose of contempt proceedings. Now, the court before whom the contempt is committed feels that the person should be given imprisonment as a sentence, or a fine above ₹200 should be imposed, or that the person should be tried by the magistrate. In these three circumstances, the court will forward the case to the magistrate for trial, and the magistrate will try the offender by following a procedure which is prescribed for cases instituted on police report. Now, the court or the magistrate has a power either to discharge the accused or cancel his punishment if the offender files apology with the court or the magistrate. Now, there are two specific provisions which are inculcated with regard to criminal courts. The first one is where the person to whom the court called either to answer a question or to produce a document refuses to answer or refuses to produce a document. In that case, the criminal court can punish the person with simple imprisonment or can put him to the custody for 7 days. If during custody also he refuses to answer or to give a document, in that case will try that person for contempt proceedings. The second provision is where a person does not appear in obedience to the summons issued to him. If there was no reasonable ground for not appearing, then the court can punish him with fine up to 500 rupees. There is a provision of appeal against the order passed in contempt proceedings, or where the person is tried for perjury by the court of session or by magistrate by following summary procedure. In both these cases, the appeal will lie to the court where the appeal ordinarily lies. But if the order is passed by court of session or by registrar or sub-registrar in case of contempt proceeding, in that case, the appeal will lie to the court of session. I hope you like the video, and for more such videos, please like, share and subscribe.